Hines Bites, your strata update, with Frank Higginson from Hines Legal.
When lawyers talk about capacity, it's normally in the context of people's mental capacity. So as aging generations, parents, competency to make decisions and so on. In strata, we really don't have that as an issue, but capacity is equally as important for anyone who wants to come and talk to us about engaging with us, particularly in relation to disputes. When you're talking about litigation or thinking about having a fight with someone in a metaphorical sense, financial capacity is the first thing that comes to mind. Can you afford what it's going to cost? And of course, the costs in any type of litigation can be a little bit variable, but that's where most people unfortunately stop. But in strata, there are a bunch of other different capacities that you need to consider. The first one is time, because the reality is that lawyers don't run matters completely on their own account. They need instructions. You're going to need to take time out of your day and the things you would rather be doing to review material, to meet with lawyers, to potentially go to hearings, and to take into account all of the things you're being asked to make decisions on. The other one then is really emotional capacity. And this really for me is a big one in strata. What's your capacity to deal with revisiting the issues that are the genesis of your dispute? Because the reality is when you're giving instructions, you're going to have to go back through stuff that happened 6 or 12 months or 18 months ago and review it to make sure it's accurate, which means you're going to get dragged back into things that might be at best distasteful and at worst extremely upsetting. The other capacity when you're involved in any type of dispute is your capacity to sleep. You're going to wake up at 2 o'clock in the morning thinking about stuff that happened, stuff that should have happened, stuff you should have done, stuff that might have been done wrong by the other side and so on. And that will continue for as long as that dispute runs along. The other thing that happens in strata that is particularly unique to strata is really for me what I call social capacity. If you're both occupying a scheme and your dispute is with another occupier, you're going to see them. You're going to run into them in the lift, you're going to see them in the pool, you're going to see them in the car park, you're going to physically eyeball them. If you're having a normal contractual dispute, you don't see the person you're arguing with. In strata, you sometimes can, and that can be exceedingly awkward. So those are all of the capacities that you need to have before you consider engaging in a strata dispute. It's not just about the money. And one final little caveat that I use for clients all the time is that courts don't declare, or courts or tribunals don't declare draws. They declare winners and they declare losers. That's a very binary choice, to use the woke term, I suppose. So it's yes or no. And no one, unless you're completely insane, goes into litigation thinking you're going to lose. So courts have 100% of people thinking they're going to win and half of them don't. So before you commence any litigation, you've got to be very realistic about your prospects and very realistic about your capacity. And if you've considered those or need help with those, just give us a shout.